The next matter to come before the court this morning is State of Ohio versus Mark Senz. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. For the appellant wish to reserve any time for rebuttal, if you let me know when you get started. I'm keeping the clock and I can let you know about the passage of time and when you're getting close or at that mark. The court is ready to proceed when you are.
Good morning, Your Honor.
Good morning.
Attorney Thomas Ryan representing the defendant appellant Mark Senz. And if I may, I'd like to reserve 5 minutes for rebuttal, please. I've argued lots of cases in front of the Court of Appeals, so I know that this court sometimes has a challenging and difficult job, but it's your job, obviously, as elected paid officials, to look at the record and look at all the details and look at all the specifics of each and every case. And I'm familiar with the last case, the Kevin Banks case, because I briefly represented Mr. Banks on appeal. So I'm going to bring the court up to speed real quick in terms of the facts of this case. So Mark Senz was indicted in a 2-count indictment. Count 1 was for petty theft, a misdemeanor. Count 2 was for complicity to commit trafficking in cocaine. Jury found him not guilty of the felony complicity, trafficking in cocaine, but guilty of count 1 for petty theft. Ultimately, Mr. Senz failed to appear for his sentencing a year plus later and was given 180 days in jail, along with a fine of $1,000, which is the maximum for the misdemeanor first degree. I'm asking the Honorable Court to do 2 things. Number 1, to reverse the conviction, and number 2, to vacate that order, that judgment of court cause. So as the court recalls, the Medina County Task Force used a confidential source to make a buy from a fellow by the name of Charles Sarno. Schuler, the CS or CI, had knowledge of Charles Sarno, and it was going to be 2 specific drug buys where he's going to buy cocaine along with the Percocets. The plan was for the CS, confidential source, CI, to go to Sarno's residence, and this was back in February of 2015. They outfit, the Medina County Task Force, they outfit, as they typically do, CI or CS with buy money, and also put on audio recording. So it's basically a communication in terms of they have him basically wired while he's going in to try to make this buy from Mr. Sarno.
Can I stop you very quickly and just, in terms of the record, I understand this is Medina County Drug Task Force and the Medina County Sheriff's Office. Did the Village of Seville Police Department have any role to play in this particular case? I'm just making sure.
I don't recall.
Okay. It didn't seem that way, but if you all had evidence that we might have a conflict, we would have to talk about. But thank you.
Okay. So it appears that the CS alerts the Medina County Task Force to something going on, so they move in, they basically detain Mr. Sarno, and they also have information of a vehicle. Now that vehicle is driven by my client, Mark Senz. Shortly thereafter, Mark Senz is pulled over in that vehicle. It turns out that Mark Senz is the brother of Charles Sarno. So they find the $60 of the buy money, $60 of the buy money, which is the subject of the petty theft, on the person or in the vehicle of my client, Mark Senz. So this matter proceeds to trial. That evidence is produced. That evidence is heard by the jury. What further happens is defendant, appellant Mark Senz, testifies. He testifies basically that Charles is helping him out. He shows up. He gets money from his brother, from Charles Sarno, to go and get some license plate. Mr. Senz testified how he's making money, doing odds and ends, including some snow shoveling. At the end of the defendant's direct, defense counsel, for whatever reason, even though Mr. Senz is 42 years old, currently 42 years old, he asks him about a drug trafficking conviction that Mr. Senz has when he's 18 years old, 24 years earlier. And one of my arguments is ineffective assistance of counsel. Why in the world are you bringing up your own client's conviction when credibility is an issue, when everything else is in dispute here from 20-some years ago. How can that be trial strategy?
You know, the interesting thing about that, though, was the jury came back and found him not guilty of the trafficking.
They absolutely did.
But found him guilty of the petty theft.
And they did.
So doesn't that cut against your argument for prejudice?
Absolutely not.
Okay. Why?
Absolutely not. Well, here, look at, what's the first thing we know from studies of juries? What's the first thing they like to know? They like to know whether or not a defendant has any prior history. And that's so often when I'm involved in a trial, we'll make that strategical decision as to whether or not to put a defendant or client on the stand. Why? Because as soon as the jury hears that he's done this before, done something before, they're more likely, it's human nature, they're more likely to not give somebody necessarily a fair shot, but judge them accordingly and more harshly because they have that prior history. Especially when credibility is an issue here, and the prosecutor, I'm sure he's going to get up there during his time and say, well, he told one story to when he was pulled over, and now he told another story on the stand. Well, maybe he did, maybe he didn't. First of all, when he's pulled over, and there was evidence of one of the agents testifying that he said he knew something was going on, and he knew there was going to be a drug deal. Well, that's not what he testified to. So my point is credibility is absolutely an issue here. And by the way, that statement supposedly attributed, allegedly, I love that word, allegedly attributed to my client was not recorded, it was not videotaped, it was not audio taped. So basically you have a quick traffic stop, and we know this day and age the most important thing when a police officer pulls somebody out of a vehicle is their safety, and as well, it should be. So, credibility is absolutely an issue here, and that's why I submit my client was prejudiced by the fact that whatever his defense counsel asks about a prior drug case when he was 18 years old. Now, I know the prosecutor is going to say, well, it was strategy, he tried to make it look like he had no involvement with his brother, but it flies in the face of logic because the prosecutor, to get into evidence a prior conviction of over 10 years, has to file a notice to do that, number one. Number two, had they intended to get that in, if the defense wouldn't have opened the door, the only way to do it is through 404B, other acts evidence. Neither of those was done. And of course, the prosecutor, being the good prosecutor who tried the case, doing his job, said, quote, "You're the guy that has trafficked in marijuana before," unquote. Well, there you go. So Mr. Sen's credibility is out the window based upon the trial tactics.
And he said whenever he was pulled over that his brother called him over and said, "Hey, I'm going to sell some fake drugs to this guy and get some money. I need your help." That's what he supposedly said.
Something to that effect, yes.
Yeah, something to that effect.
Something to that effect.
So I'm still having a hard time saying how he was prejudiced by this, because you would think, based on your years of experience with jurors, like you said, not giving them the benefit of the doubt, hearing that he had a prior drug offense, even trafficking, then the confidential informant saying that, what's his name, Sarno, said that I have a guy coming with the drugs, which, whether that was true or not, obviously, but the point is, he says, I have a guy coming with the drugs. Confidential informant testifies to this. The brother, the defendant here, says, my brother wanted me to come over and help with a drug deal. And then hearing that he had a prior conviction for drugs, the jury still goes back and finds him not guilty of trafficking in drugs.
As well they should, because there's no evidence that he was.
Well, that goes to my point. So they were able to, but it seems to me that they were able to put those feelings, like you said, of maybe not getting him the benefit of the doubt or hearing about this prior drug offense, they were able to put that aside.
Maybe yes, maybe no. But I submit, too, that in all likelihood, they would have found him not guilty of everything, so therefore he was prejudiced. And I don't want to waste all my time.
No, I'm not trying to hold you up on
that.
that. I'm
just
trying to figure it out myself.
But here's the other thing, and I raised this as well. So, let's see what he was convicted of and taking a look at the indictment. Mark Senz unlawfully did with purpose to deprive the Medina County Task Force / Medina County Commissioners, the owner of property or services, to a U.S. currency. So, I think that's very specific here. It says, with purpose, so it's specific intent as opposed to knowingly, purpose to deprive the Medina County Task Force / Medina County Commissioners. Interestingly enough, the victim then how would Mr. Senz know that he's depriving the Medina County Task Force? He knew nothing about the police even being involved in this. And the way they indicted this, the way the Medina County grand jury indicted this, they did not indict it the same way they indicted count 2 with the complicity. He was charged with petty theft with no complicity. And therefore, how could he ever know, specifically or generally, that the victim was the Medina County Drug Task Force / Medina County Commissioner? He wouldn't have known that. He would not have known that. There's no evidence that he knew that. There's no evidence in the record, there's no evidence in the world, there's no evidence in the universe that he would have known. Maybe even given what Judge Carr's pointed questions, maybe, even if he thought, in the best case scenario, towards evidence most favorable to the state, that he knew he was depriving somebody, he would have been depriving the CS or CI or the buyer, not the Medina County Drug Task Force, Medina County Drug Task Force / Medina County Commissioners.
You just now reaching into that 5 minutes.
Okay, I will quickly move on to my next argument. I submit that the fine of $1,000 is punitive. 2947.14, you have to have a hearing on ability to pay a fine. The court waived the court cost but imposed a $1,000 fine. I understand the court gave a 180-day sentence because he didn't show up as a result of being there at the proper sentencing date originally, but no hearing was held on the ability to pay, and therefore that fine must be vacated. So in summary, I know I'll get to my rebuttal, but I'm asking this honorable court to reverse this conviction for those reasons, specifically ineffective assistance of counsel, the fact that the proper victim was not named in the indictment, there's no evidence the proper victim was named or did this, and that the court failed to hold a hearing as to the financial issues. Thank you very much, Your Honor.
Morning again, Your Honors. I'm Vince Vellucci with the Medina County Prosecutor's Office for the appellee of the state of Ohio. I will start out with Mr. Senz's first, I guess, and second assignments of error. That's the sufficiency and the manifest weight challenges. Mr. Senz primarily disputes that he knowingly stole the Drug Task Force's $60. He apparently is arguing that he never admitted that he was part of the plan to rip off the Drug Task Force's confidential source, or the man that turned out to be the Drug Task Force's confidential source that had their money. But he made exactly this admission at the scene shortly after he left Mr. Sarno's house and was pulled over holding the Drug Task Force's money. After being Mirandized, Director Hubbard of the Drug Task Force spoke to Senz about what had just happened. Senz stated that Mr. Sarno had called him earlier in the day. He gave a real detailed description of everything that he had done that day. He had called him earlier that day and asked him if he wanted to make $50.
I think he's saying that he may have admitted that he was part of a plan to rip off an addict, but he had no idea that, obviously, that the person they were dealing with was a confidential informant, or else I would suspect he wouldn't have shown up that day.
Maybe a safe assumption.
Do you think that it is required that he know he was, the way the case is indicted, do you think that element of knowingly goes to reaches the Medina Task Force?
I don't think so. And I think he knew that he was ripping off somebody who was not Mr. Sarno, who was in Mr. Sarno's house doing a deal with him.
Well, first of all, I'm going to interrupt just a second so I can, but keep answering his question. Do you agree the indictment says with the purpose to deprive the Medina County Task Force?
I believe that is what it says. I haven't looked at it in a little while, but
okay,
I have no reason to think that isn't what it says.
Okay, so I'm sorry, now I'll go ahead and answer his question. I apologize, but I just wanted to make sure we all agree that that's what the indictment said.
And I think Mr. Senz's description is very specific. He says Mr. Sarno told him a guy was coming over to buy drugs, and Mr. Sarno planned to rip that guy off with fake drugs. He stated that Senz, I should say, stated that he agreed to help with this plan and arrived at Mr. Sarno's house for that purpose around 5:00 p.m. that day. When he arrived, he described Mr. Sarno walking out of the house and handing him actually $60. So we got a $10 bonus there.
But I think Judge Theodosio's question specifically is, and correct me if I'm wrong, Judge, but didn't the state have to prove that he intended to deprive the Medina County Drug Task Force of $60?
I don't believe so.
So it's irrelevant what you put in the indictment?
I don't think it's irrelevant, but, you know, in terms of, I would almost equate it to, you go into a store and you shoplift, and the store says one thing on it, and, you know, maybe it's a DBA, but it's actually a big corporation, it's a conglomerate. You don't know who that parent corporation is, who they are, but you're stealing from them. Nonetheless, it's kind of the same thing here. You're stealing from this confidential source. It's your intent. You know at the time exactly what you're doing. You just don't know exactly who you're stealing from. I don't think that's ever a required element, that you know who the person 3 rungs above is. That is
So
ultimately
why was that in the indictment?
I'm not sure, Your Honor. I really
Because you could have indicted just with intent to deprive the owner.
True, that's true. It could have been no to wit, nothing. It could have just been, and I think it would have been just fine. And I think that underscores the point, actually. It's superfluous language, really, is what it sounds like to me in the indictment. It was not even required. Again, I don't think you have to get right exactly who was deprived in every theft indictment, or you'd have a lot of these getting reversed and sent back. That just isn't what the law is.
So you think that was more along the lines of identifying who the owner of the stolen property was?
Yeah, yes.
That's why it was inserted. Is that your?
I think so. I would mention that, you know, at the scene, Mr. Senz did not attempt to say that Mr. Sarno tricked him. He did not say anything about not knowing exactly what was going on. That's what he said. He said that he knew exactly what was going on. He was found with $60 of the Drug Task Force's money in his hands. And that's just the direct evidence. I think the circumstantial evidence is also compelling in this case. If you look at the fact that Mr. Senz admitted that he knew his brother was a drug dealer, he made that admission at trial. Then he tries to say that he was just going over there to get a $60 loan, apparently. That really defies belief when you look at all the circumstances. And in a sufficiency review, you have to, of course, accept all of the state's evidence being as true. So you have to accept Director Hubbard's testimony about what Senz told him as true. And that is sufficient to prove Senz's knowledge and involvement in a theft by deception.
Counsel, I have bear with me with this question, but when I was reading this, it just kept occurring to me that there may be some public policy ramifications with the state's charge here of petty theft. If this were not the Medina County Drug Task Force that were involved, say this was just Joe Smith off the street that had made arrangements to buy drugs from a drug dealer and he got counterfeit drugs instead, we know that's an offense, okay? And that's a criminal offense that can be prosecuted. However, civilly, Joe Smith could not sue the drug dealer and say, breach of contract or, failure to perform, whatever you want to say, because we would say that's against public policy because this was an illegal transaction. So if this were Joe Smith's money and Joe Smith didn't get the drugs that he was supposedly buying but got counterfeit drugs, would the drug dealer or the accomplice be charged with petty theft in that circumstance? Because really, aren't we kind of like talking about theft of illegal, it would be contraband, all the money anyway? It seems like it's almost a public policy problem.
In that case, I think it would be highly unlikely. it's also unlikely that they'd be reported by somebody who is engaged in a drug deal, because then you're implicating yourself as well. So,
But there could be a raid, there could be any number of things, you know. It could be just a tip and they pull the guy over, or it could, the drug force doesn't have to necessarily be involved from the start.
I agree, but I think that is a very different situation than what we had here with an actual undercover operation, sting operation really, by the drug task force.
So I guess that goes back to the indictment, is this different because this is clean money and not contraband? And so would you have to prove that they knew? I mean, you see what I'm saying? This is a very unusual type of situation.
It is, it certainly is, and I think it is different, that this is, this turns out to be clean money and it's not drug money. Yeah, I think that does change the entire analysis of what we have here.
I don't know what this all means. I'm good at throwing out questions. I don't know exact answers,
Figure
but
that out
I'm good
later.
at throwing out questions. Okay, thank you.
Thank you. I would just go into the manifest weight aspect of this, and it really does, there certainly is a credibility that had to be weighed, and that was the jury's problems to do that. Weighing Director Hubbard about, what he says that Senz told him at the scene versus what Senz says happened at the scene. Senz, of course, confesses that there's that a theft by deception took place at the scene. Never says anything about, oh, I was just going to get a loan. He changes his story then at trial. But he does admit that Sarno was a drug dealer, and I think that is significant when you look at all the circumstances and whose story is more credible. The jury clearly chose to credit Director Hubbard's testimony over Senz's, as it was their right to do. I don't think this decision is really surprising either, given that Director Hubbard has been a police officer for over 35 years, and he never changed his story from what happened at the scene to trial. Whereas Senz completely changes his story and admits that he knew Sarno was a drug dealer. This court has repeatedly held that the conviction is not against the manifest weight of the evidence simply because the jury chose to credit the state's witnesses over the defendants. In terms of the third assignment of error, I want to get into the ineffective assistance part of this, and that had to do with Mr. Senz's counsel asking him about a 1993 marijuana trafficking conviction. And here, we know under the Strickland test that Senz has to prove not only that his counsel's performance was deficient, but that he was prejudiced by this. If you look at the whole exchange in the transcript, it does appear that Senz's counsel's main purpose in this line of questioning was to establish to the jury that Senz had never been involved in any drug dealing activities with his brother before. And as was mentioned, there was also a drug trafficking charge that he was on the line for in this case and was ultimately acquitted of. So you have to take that whole, I think, thing into context. But I think the purpose was also to tell the jury that Senz had not trafficked in drugs himself for over 20 years. I think by mentioning that old trafficking conviction, Senz's trial counsel was attempting to give his client an air of openness and honesty and credibility. If he was willing to tell the truth now about something that happened 20 years ago.
But did the state have the ability to put forth that evidence? I mean, they didn't file a notice that they intended to use it. How else would they have put that before the jury?
Well, I think this was 404B other acts evidence that could have been introduced to show Mr. Senz's knowledge, intent, plan, absence of mistake or accident. All of those things under 404B I think could have been introduced. I don't think it comes out in the record as to whether the state of Ohio had filed a notice necessarily actually. I'm not sure either way on that question, but,
As to whether or not the record indicates filing of the notice, you're not sure that's in the record?
I think actually there was not a notice filed, now that I'm thinking about it. But that would not necessarily have been fatal to the state, just because a notice had not been filed before trial. The trial court in its discretion still could have allowed the state to give notice during the trial, and they still could have allowed this in. I mean, that is not necessarily fatal. So I think the state could have still gotten this 404B evidence in. But aside from that, in terms of the strategy of the trial counsel in eliciting this trafficking conviction, this court should not be in the business of second-guessing strategic decisions of trial counsel. Scrutiny has to be, of course, highly deferential and the strategy presumed to be sound. And I've just given, I think, some very plausible reasons why counsel may have chosen to go in this direction. And that this may not only have not prejudiced Mr. Senz, but this may have actually improved his credibility.
Well, did he argue in closing statements, statement to the jury, look, my client has been forthcoming with you and has told you about his prior conviction for drug trafficking? So it shows you, ladies and gentlemen of the jury, that he's, you know, an honest guy. He's being honest here. I can't say maybe honest, but you know what I'm saying, that he's been forthcoming with you.
I don't recall if that argument was made in closing. I don't think it necessarily has to be to have the desired effect of making the client seem more credible in terms of, he was weighing that in his mind. I'm sorry?
Don't you somehow have to connect the dots? Otherwise, it just sounds like he's a drug dealer.
Well, I think he was weighing the being honest part of this with 20-year-old conviction. The fact that it's been 20 years, I think, limits the prejudice severely here. The fact that it has been this long, that he's been clean, I think that's part of the calculation, and I think that was the weighing that the trial counsel did in its mind, and I don't think that's something that this court has second-guessed and should be second-guessing.
And counsel, I need to inform you, be the last 15 minutes of time today.
Thank you, Your Honor. I would just respectfully request that this court affirm the judgment of the trial court. Thank you.
Thank you. You have 4 minutes remaining.
Thank you, Your Honor. It may please the court. I used to deal drugs 20 years ago. I didn't do it this time. I had a nickel for it any time one of my clients said, well, maybe I did that way, I did those other 4 or 5 things. I didn't do this time. Come on. It's not even, I'm not even sure the prosecutor believes his own argument. And he just basically told this honorable panel that this court should never review strategic decisions in the midst of trial. Really? What in the world was defense counsel thinking when he asks his client that question? And why? And of course the prosecutor is supposed to jump on it. Then the prosecutor, of course, I'll remind the court, says, you're the guy that has trafficked marijuana before. Of course he's got to jump on it. There was no 440B notice filed.
Well, I think the prosecutor is just saying that it's a high standard. I mean, you know, we are to presume that every licensed attorney in Ohio is competent. That's our starting point. And that we are to give deference to trial strategy. That doesn't mean we always say that it was right, but that's why you have the second prong as well, with the prejudice.
Well, if you're going to choose to put your client on the stand, then you better make sure that you cover yourself in terms of putting the reasons on as to why you're asking that specific question to your client.
Do you know what he did argue in closing argument?
I don't recall.
Okay,
I don't recall specifically.
Of course, in this case, the acquittal on the aggravated trafficking charge makes it difficult to find that he was ineffective, at least in defending the most serious charge in the case.
Well, maybe yes, maybe no. Maybe yes, maybe no. My position is that he should have never asked in the first place, and the prosecutors on rebuttal or his
I
said,
mean,
well,
if it destroyed your, Mr. Senz's credibility,
oh, I think it did. Here, of course I
do you
think it
think that
did.
they would have come back with a guilty verdict on the trafficking when they basically he admitted to a prior traffic.
But what's all of a sudden though, but here, they didn't, again, we don't have video cameras in juries, we don't have that yet in Ohio. I know some states do, we have the post-jury interviews unless you're watching CNN or MSNBC or court watch, stuff like that. No, I just think it's trial strategy here, it doesn't, if it's, you can even consider strategy or tragedy, I would paraphrase it. No, why were you gonna put on the fact that your client's got a record from 24 years ago, but he didn't do this one, when Medina County Task Force is involved in that particular case? It just doesn't make sense. The prejudice is not limited severely, it rises to the level of ineffective assistance of the counsel. I want to use the rest of my time, I think, that point too. In terms of the indictment, again, going back to my point with purpose to deprive the Medina County Drug Task Force, it's not only the indictment, I believe also that's what the jury was told in terms of its jury instructions. So the trial court told the jury, before you can find Mr. Senz guilty of theft, you have to, beyond a reasonable doubt, find that he did with purpose to deprive the Medina County Task Force of that said money. What the prosecutor could have done, under Rule 7D at any time, asked to amend the indictment, throw on there and or the CS. Or the Medina County grand jury could have indicted for complicity to petty theft. Then maybe I wouldn't have that as strong an argument. The prosecutor's office did neither of those, the state of Ohio did neither of those. I submit again that his conviction needs to be vacated and or reversed, and the $1,000 fine, which is punitive without a hearing to determine ability to pay, needs to be vacated as well.
Did the court, what about the PSI not being part of the record here, and the presumption that the court utilized it in making sentencing decisions, do you think? You want to reply to that?
2947.14 requires that before assessing a financial sanction that the court must hold a hearing. So there was nothing said. The hearing itself cannot say, I oppose, you're getting 180 days in jail, you are getting $1,000, I'm waiving court costs, but you're getting a $1,000 fine.
But the prosecution is saying, the state is saying that only kicks in on felonies, not misdemeanors.
Well, I would disagree with that. I would think that back in the day, if I want to go back to my law school days, Gideon versus Wainwright, I think any time you have a financial sanction or you have somebody who faces the potential of incarceration, which includes a misdemeanor M1, that comes into play as well. Therefore, it does come into play, and that fine must be vacated.
Thank you, Counselor.
Thank you, Your Honor.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed to both sides as well as posted on the House Supreme Court website.
Thank you, Your Honor.